drive.
Pause right here. This is the legal tipping point. In death penalty cases, the jury doesn't just decide guilt, they must unanimously agree that the aggravating factors outweigh mitigation beyond a reasonable doubt. That's the highest standard in the system. Question for you. After hearing what you've heard so far, do you think that balance was already locked in at this moment?
Okay. Once again, be seated, ladies and gentlemen. Okay, ladies and gentlemen, once again, I thank you for your patience. In every jury trial, the court tells the jury to evaluate the case on the law as it is given to them. The court admonishes them not to apply their own conception of what they believe the law should be. I can follow no different directive. On Thursday of last week, the jury found that the aggravating circumstances outweighed the mitigating factors beyond reasonable doubt, and therefore found the verdict of death to be appropriate. The defendant on numerous occasions indicated to the court that he would not be presenting mitigating evidence. Upon announcement of the verdict, he indicated that he did want to have an evaluation performed. The court prevailed upon the court psychiatric clinic to prepare a mitigation report. The defendant issued a subpoena to have the doctor appear in court. When it was time to call the doctor to the stand, the defendant rested, much to the surprise and the chagrin of the court. A sidebar conference was held, and the defendant, acting pro se, stood fast and rested. Thereafter, closing arguments were heard and the jury charged. The jury verdict was returned and read. The jury was polled and discharged. The defendant then requested that the court review both the pre-sentence investigation report and the mitigation report, neither of which were submitted to the jury. The court did review these documents and has evaluated this case in conjunction with the mitigation phase and the mitigation factors of 292904B of the Ohio Revised Code, as well as the statements adduced herein today. In addition to the mitigating factors in ORC 292904B, the court has considered the statements of 6 family members, all of whom relate that the defendant had a tough childhood. His older sister indicated that at age 5, he found his mother's gun and shot himself in the leg. The mitigation report, prepared by the court psychiatric clinic, adds some more significant insight. He found his mother's body after she OD'd on heroin when he was 19. He was hit on the head with a brick at age 12 and suffers from seizures. At age 9, he was repeatedly raped by his mother's male friend. According to a 2008 psych evaluation, the defendant has chronic problems with anger and has little regard for authority. There was a suicide attempt at the Euclid jail in 2006. Dr. Radio.
This is where things get complicated and controversial. You're hearing horrific trauma, abuse, and diagnosed PTSD, but also medical professionals saying the defendant can think and behave logically. Legally, mitigation doesn't excuse the crime. It only asks whether it lessens moral blame. Here's the hard question. Should a traumatic childhood ever carry enough weight to counter a death sentence?
Diagnosed him as having post-traumatic stress disorder. And finally, a 2018 evaluation at the Moritz Forensic Unit at Twin Valley Behavioral Healthcare observed the defendant interacted appropriately and logically with staff and others. Notwithstanding these mitigatory observations, the court, after carefully weighing the statutory mitigation elements, the testimony of the defendant's witnesses, the unsworn statement of the defendant, and the pre-sentence report and psychological evaluation report, the court finds that the aggravating circumstances do outweigh the mitigating factors with proof beyond reasonable doubt. At this point in time, Mr. Mazzone.
Thank you, Your Honor. Your Honor,
With regard to the sentencing on the other 8 counts, that the non-homicide counts that remain, first and foremost, Your Honor, the state of Ohio, we're only here today as a collective effort and a team effort, and the state wants to thank the Cleveland Police Department, including the homicide unit, the crime scene unit, the scientific investigation unit, and the 5th District, the FBI, the Medical Examiner's Office, and the Cuyahoga County Regional Forensic Science Laboratory. Without these entities, we can't put a thorough case on as we did in this matter, and we can't produce and establish and present evidence as overwhelming as we were able to do in this particular case. Before the state says its piece, Your Honor, I know this would be an appropriate time for family members typically to address the court. Nobody from the family wishes to address the court in open court at this time. However, Your Honor, I don't want you to think that they certainly aren't feeling the effects of this, Your Honor. You've seen them sitting in the courtroom every single day of this trial, from the time we began the general voir dire until up to and including today behind me. Your Honor, over the last 2 years, the Kuzniks, the Zakowskis, they've been with us every step of the way and have been more than patient, and we've had their full support, but they do not wish to address in open court today. However, Your Honor, as you're well aware, the murders of Michael and Trina and the subsequent closing, the necessary closing of Mr. Carr's, had a great effect on the North Collinwood neighborhood. And the businesses in the area, the families in the area, and Your Honor, at this time, on behalf of the neighborhood, on behalf of the citizens of Collinwood, Councilman Mike Polensek would like to address the court.
Thank you. Councilman?
Thank you, Your Honor. I too would like to thank the jury, Cuyahoga County Prosecutor Michael Malley and his magnificent team of prosecutors, Detective Eccles, members of CPD, the homicide unit, the 5th District, and all the other law enforcement agencies that were involved in this process. Your Honor, from day one, this was never about vengeance. It's been about justice. I stood there on that Good Friday night as they carried out Mike and Trina and Axel in body bags. I was there. I saw the pictures from the coroner. I saw what this individual did to them, the viciousness of the crime. He is a demonic killer, a demonic killer. It's one thing to rob somebody, but it's another thing to do what he did. Him and his cohorts, what they are predators. They prey upon our communities, upon our businesses, upon our citizens, and as we try to stabilize and rebuild our neighborhoods and our city, this is what we have to be confronted with. The North Shore Collinwood area, the greater Collinwood community is a great neighborhood. This crime on Good Friday not only devastated the family and tore that family apart, it devastated the community because they didn't know, the businesses didn't know who was going to be next, if there's going to be somebody else. It could have been somebody else. It was Mike and Trina. It was their night to be preyed upon by him and his cohorts. What we want, Judge, and what we're asking for is justice on behalf of the people, of the community, and on behalf of Mike and Trina's family. He'll be around tomorrow. Mike and Trina aren't. They are not there. I saw what happened to that family. I saw what happened to that business. I've known this family for almost 40 years, how they contributed to our community, how they were supportive of one event, one activity after another. Since that brutal murders, that business has been closed. Other businesses have been apprehensive whether to invest in the community. But you know what? We're not going to let him and the other 2 parasites that were with him destroy our neighborhood. We're not going to let them destroy communities. We're going to rise above it, not only in this community, but across the entire city. That's the message we're looking for the court to send today, that when you commit these atrocities, there's a price to pay. There's a price to pay. And all the work that these fine folks did here, all the investigators, was not in vain. And to remember what this family has gone through. I know how many times I've talked to them on a phone and have heard and the pain in their voice, saw what happened. was there. We want and deserve justice on behalf of Mike and Trina and Axel, on behalf of the greater community. Thank you.
Thank you, Councilman.
Thank you, Your Honor. May it please the court again. Your Honor, with regard to the non-capital counts, the 8 remaining counts, the state is here today to first ask for consecutive sentences. Your Honor, pursuant to the Ohio Revised Code, we believe that consecutive sentences are necessary to protect the public from future crime, not only to punish the offender, and that they would not be disproportionate to the seriousness of his conduct and to the danger he poses to the public. Your Honor, you heard during the mitigation phase of this trial that the defendant has a long and sordid criminal history, a juvenile record of at least 13 adjudications, and a trip to ODYS did nothing to rehabilitate him. As a young adult, he committed a burglary, was placed on probation, and while on probation, went ahead and robbed somebody at knife point. The defendant did 8.5 years in prison and still was not rehabilitated. He came out, and 6 months later, on Good Friday, on April 14th of 2017, walked into Mr. Carr's on Lakeshore Boulevard and ended the lives of 2 innocent people, killed a dog, and forever altered the lives of their family. Your Honor, the third prong that you need to consider is that you must find that one of the 3 statutory factors are present, and that's that the offender committed one or more of the offenses while he was under post-release control for a prior offense. Well, he was. He was on post-release control for his 2008 burglary. At least 2 of the multiple offenses were committed as part of one or more courses of conduct, and the harm caused by those was so great or unusual that no single prison term would adequately reflect the seriousness. Your Honor, he killed 2 people. For what? As Mr. Schroeder stated last week, for some cash and 2 used cars to end 2 lives and a dog? And that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crimes. It's been abundantly clear, Your Honor. All 3 of these prongs, of which you need only meet one, apply to Joseph McAlpin. The one thing we didn't hear today, Your Honor, was any remorse for the crime. We didn't hear any condolences to the family. The only ones we heard were the half-hearted attempts while questioning witnesses, making his self-serving, unsworn statement, and in his closing argument. And the one thing that he repeatedly talked about during his argument was family. That the state's going to commit an aggravated murder with prior calculation and design of him without considering his family or the fact that he has kids or grandkids or that he's a son and a brother or a nephew or an uncle and a nephew. But Your Honor, the defendant is sitting there today because of his actions, his choices. Colin, Corinne, and young Kane are without a mother, a father, a stepfather, a stepmother because of his actions through no fault of their own. They're without a dog, a family dog that was loved by Colin, used to go with him everywhere because of his actions through no fault of Colin's, through no fault of Corinne's, through no fault of Kane's or any of their other loved ones. Michael and Trina were a son and a daughter. They were an aunt and an uncle. They also had people that loved them. And you heard testimony, Your Honor, through the course of 5 weeks. Mr. Carr's was like a family. It was a second home, as Colin called it. One of the ironic things about the timing of this trial was not only were we in session on the 2-year anniversary of the homicides on April 14th, but Randy Kuznick opened Mr. Carr's on April 1st of 1977. So we sat through this trial that effectively closed that business forever on the 42nd anniversary of its opening. You heard Colin testify that they had repeat customers for years and years. Something was wrong with the car, bring it back. Mike, Butch, one of them would fix it. It was almost like a lifetime warranty. You saw the people that they dealt with. You heard testimony from Daryl Sanders, the last person who had any contact with either Michael or Trina when he spoke with Trina at 5:30 p.m. on April 14th to tell her there was a problem with the title. He had known them for 10 years. He was still buying cars from them. In fact, he thought he may have paid too much for a used minivan, but still had no problem calling them, and they decided they'd work it out on Monday. You heard from Albert Martin. Albert's led a rough life, but you heard that Mike and Trina kept him around to do odd jobs around the dealership because it kept him out of trouble. It kept him off drugs. It was something for him to do. Your Honor walked through that dealership on the jury view. You saw Michael and Trina's Ford Focus that you saw in the video that was parked out on Lakeshore Boulevard. And you saw that Corinne and Kane's Easter baskets were still sitting in the back seat of that car 2 years later. The family that will never be the same are both families. But the striking difference, Your Honor, is that Mr. McAlpin's family won't be the same because of Mr. McAlpin's choices, because of his actions, and through no fault of the Kuzniks and the Zakowskis and their loved ones and their children, they will never see or speak with their loved ones again. And every year, regardless of whether it's April 14th or at the end of March, Good Friday will always have a significance to them. So they get it double. They get it Good Friday and on April 14th. Another holiday without their family members. Your Honor, the lasting effects that this case is going to have on the families of Michael and Trina necessitate consecutive sentences. The state would ask that you sentence on each of those 8 counts a maximum possible sentence and run them each consecutive to each other. Thank you.
Okay, one housekeeping matter. We've got 1 year and 3 year firearm specifications for merger.
Your Honor, each of those aggravated murder counts would have a 3 years firearm specification pursuant to Revised Code 2914B1G. Your Honor is required to run the 2 most serious firearm specifications for aggravated murder, aggravated burglary, or aggravated robbery consecutive to one another and everything else. So we would ask that after those first 2, I would agree that they would merge.
Okay, and you prefer to have it set, go forward under the 3 year gun spec?
Correct.
So we.
Thank you, Your Honor.
Very good. Okay, the court's going to proceed to impose sentence at this time. With regard to count number 1, the aggravated murder of Trina Tamola Kuznick, the court's going to impose a sentence of death plus 3 years on the firearm specification. Count number 2 for the aggravated murder of Michael Kuznick, death plus 3 years on the firearm specification. Count number 8, aggravated robbery. This involves the robbery of Trina. 11 years plus 3 years for the gun specification, consecutive to each other. Did I say count 8?
Yes.
Thank you. Count number 7, going a little out of order here. Aggravated robbery of Michael, 11 years plus 3 years for the firearm specification. Count number 11, aggravated burglary on Trina, 11 years plus 3 years for the gun specification. Count number 12, aggravated burglary of Mike, 11 years plus 3 years on the firearm specification. Having a weapon while under disability, count 21, 36 months. Count 23 and 24, both grand theft, 18 months each. And count number 26, cruelty to animals, 12 months. Counts 21, 23, 24, and 26 do not have any specifications attached thereto. With regard to the case at Chief, obviously, counts 7, 8, 11, 12, 21, 23, 24, and 26 will in fact be served consecutive to each other, and this is necessary to properly protect the public from any future crimes that the defendant might commit and are proportionate to the seriousness of the offense. And finally, the court does observe, as stated in the pre-sentence report, that the defendant was on post-release control when he committed the offense and does have an extensive criminal history. Is there anything further? I don't think I've overlooked anything, but double check now, please. Oh, yeah.
Your Honor,
Yes.
just for clarification of the record, just want to make sure your findings that the aggravating circumstances outweigh the mitigation in both counts 1 and 2 applies to each.
That's correct.
Thank you, Your Honor. That's it.
Yeah, I didn't say both counts, but yeah, that was what I was trying to imply.
Your Honor, also there, I mean, I know it may be a moot issue, but a post-release control.
I was just going to take care of that, in fact, yeah. 5 years mandatory post-release control relative to counts 7, 8, 11, and 12. 3 years post-release control with regard to counts 21, 23, 24, and 26. Obviously, 5 years would be guiding, and kind of moot, but nonetheless, I think that properly takes care of all the sentencing. What do you think? We're done? Okay, Mr. McAlpin, you do have the right to appeal this case. You have the right to have transcripts prepared. If you cannot afford the cost of appeal, the court will appoint or will pay for the cost of preparation of transcript and order the documents prepared without cost. And you have the right to have a notice of appeal timely filed on your behalf. Mr. McAlpin, I assume you want this case appealed?
Yes, Your Honor.
Okay. And unless you indicate otherwise later, the court will appoint Thomas Ryan to represent you. And because this is capital, I will appoint Bob Dixon to be a second appeals attorney on this. And
Excuse me, Your Honor, you said Thomas Ryan?
Thomas Ryan,
I
R-I-E.
believe I had him before that's not, we had him before, we have.
Can we have a brief sidebar on that, Your Honor?
Certainly.
I don't know if I'm approaching.
Yeah, you're still in this. What do you want?
Yeah, he represented him in his 2008 court case initially.
Oh, yes. Okay, no problem on that. Okay, we're going to appoint Bob Dixon to represent you. I'll appoint a second when I review the assigned counsel to see who is appeal eligible and has the necessary background. One last matter that was brought up at sidebar is that it's kind of silly under this case, but if you violate the terms and conditions of post-release control, any violation will result in additional prison time under this case number not to exceed 50% again, that which the trial court has put into place. Okay.
And also, Your Honor, for the record, just facts and findings and the conclusion of law for the hearing we had on the 13th.
Absolutely, absolutely. That I haven't forgotten about you. Anything else?
One more, Your Honor. Nothing.
Well, you are indigent.
Yeah, that's what yeah.
Okay. Court costs will be suspended in this case.
Thank you, Your Honor.
Thank you.
Please rise.
And just like that, the final line is drawn, not between guilt and innocence, but between life and death. Because in cases like this, the question is never simple. The jury had already decided. They concluded that the aggravating factors outweighed the mitigation beyond a reasonable doubt, the highest standard in the legal system. But even then, the story didn't end there, because what followed was something far more complicated. You heard about the trauma, a childhood filled with violence, abuse, neglect, moments that would break most people long before adulthood. You heard about mental health, PTSD, a life shaped by pain most of us will never understand. And for a moment, it forces a difficult question. Does suffering ever reduce responsibility? Can a broken past outweigh irreversible actions? Because while the defense tried to show a life worth understanding, the prosecution showed something else. A pattern, a history, a series of choices that led to one devastating outcome. 2 lives taken, a family destroyed, a community shaken to its core. And when the judge weighed all of it together, the conclusion was clear. Not emotional, not reactive, but calculated. Aggravation outweighs mitigation. And with that, the sentence was delivered. Death, plus years stacked on top, as if the system itself was trying to make a point that some actions carry consequences beyond comprehension. But even now, the hardest part isn't the sentence. It's what it represents. Because this wasn't just about one man. It was about two victims who will never come back, a family that will relive this moment every year, every holiday, every memory, and a community left asking how something like this ever happens in the first place. Because justice, in a courtroom, is precise. It's structured. It follows rules. But outside, justice feels different. It feels like loss, like silence, like questions that never get answered. And maybe that's why cases like this stay with us. Because no matter what side you stand on, no matter what you believe about punishment, there's one truth that doesn't change. Nothing can undo what's already been done. So the real question isn't just whether justice was served. The real question is, was there ever a point where this outcome could have been prevented? Or was this ending, inevitable all along,